The Supreme Court is set to hear oral arguments tomorrow on President Trump's executive order that looks to end birthright citizenship. It is a major test for Trump's immigration agenda and marks the first time the justices will weigh the legal merits of one of the president's immigration policies,
I'm so confused. Let's bring in right now Democratic Attorney General Rob Bonta of California. He's co-leading a coalition of more than 20 state attorneys supporting the challenge to Donald Trump's executive order to abolish the 14th Amendment.
I mean,
to abolish.
I'm channeling your energy.
Also with us, the great MS Now senior legal reporter Lisa Rubin. I mean, Mr. Attorney General, I must say, you read the 14th Amendment, it could not be more clear. Like, the Supreme Court threw out this racist argument in 1898. 1898. I will tell you truthfully, the reason I am actually excited about this is because I want to know if Clarence Thomas and Alito both decide they're going to have the guts to side with Donald Trump in abolishing the 14th Amendment, because the clear language of the 14th Amendment states what birthright citizenship is. All persons born or naturalized in the United States are citizens of the United States. And Donald Trump is trying to get that overturned. Mr. Attorney General, I just...
Joe's got his popcorn out.
Forgive me. How could any justice of the United States Supreme Court side with a president who wants to abolish the 14th Amendment?
I agree with you, and I channel all your energy.
All right, thank you so much. Mr. Attorney General, thank you so much for being with us.
Yes,
we appreciate it. You can, go ahead, Mr. Attorney General. I'm sorry.
No, I appreciate it. You know, this is a remarkable action, as you stated. Donald Trump tried to rewrite the Constitution with the stroke of a pen with an executive order. There is a way to amend the Constitution if he wants to have a constitutional convention or marshal the votes in 2/3 of each house and get 3/4 of the states to ratify. But this is about whether the Constitution means what it says. And it says exactly as you set forth, that if you are a person born in the United States, you're an American citizen, period, full stop. That's what the 14th Amendment said back over 150 years ago. The Wong and Kim Ark U.S. Supreme Court case issues precedent on this very issue and says the same thing and upholds birthright citizenship. Every lower court leading up to the U.S. Supreme Court has agreed that the Constitution, the 14th Amendment, the Citizenship Clause, means what it says. And so this one should be very straightforward. It should be a 9-0 vote in front of the U.S. Supreme Court. We'll see how that turns out. But there are some arguments the United States is making around transience versus permanence, around loyalty to the United States. These are more fringe theories that have never been adopted by courts and shouldn't be adopted here. So we're confident and hopeful as we go into the argument tomorrow that the birthright citizenship clause will be upheld.
So, Lisa, this feels pretty straightforward. As the Attorney General said, it feels pretty settled, but yet the government is making some of these arguments. President Trump is on Truth Social nearly every day pushing for this to be overturned. Walk us through a little bit about some of the arguments that are being made, and even haven't some of these been sort of heard in the past?
Absolutely. This is a recycling of arguments that have been made since and prior to the 1898 decision that the Attorney General and Joe were just talking about. They were made at that point primarily as a basis to exclude Chinese immigrants from the United States. Now it seems like they are being adopted again as part of a Stephen Miller-led project to change the definition of who is an American and who counts. But what it hinges on, Jonathan, is the phrase subject to the jurisdiction of. To you and me and the Attorney General, that likely means if you're subject to the jurisdiction of the United States and its laws, it means you can be criminally prosecuted, for example. Nobody contests, for example, that undocumented immigrants are criminally prosecuted every day. In fact, this Department of Justice has made that more of a priority than ever before. But the administration says subject to the jurisdiction of means you have pledged fidelity to the United States government and you are entitled to protection from it. If that's the meaning of that phrase, that helps them narrow the definition of the citizenship clause to exclude people like the children of undocumented immigrants, as well as foreign diplomats, for example, or wartime conquerors.
So, Mr. Attorney General, the administration is actually relying on the legal theories of just out-and-out racists from the 1800s. I don't mean to be I don't mean to be naive here, but how could any Supreme Court justice take the side of bigots and racists from the 1800s, again, whose arguments were rejected by a Supreme Court in 1898? And if I'm not mistaken, I think that's about the same time as Plessy Plessy and separate but equal. This wasn't an enlightened court that ruled in 1898, was it?
I mean, the court ruled very clearly in 1898 that shouldn't change now. The arguments of the United States government they're really reaching and stretching. They have racist undertones or explicitly racist. And, this is just a straight up application of the U.S. Constitution, the Immigration and Nationality Act, and prior precedent in the form of the Wong Kim Ark case and other cases. So, there's some cases that are more difficult. This one shouldn't be. I'm hoping for a 9-0, but we'll see.
Lisa, final thoughts.
Joe, one of the things that strikes me here is that there is also a problem here sort of in terms of how the executive order works. One of the things it says is that if the mother is present, even lawfully but temporarily, the child does not get citizenship. You can see how from even an equal protection perspective, that's really problematic. A woman could come here on a student visa and tend to be here permanently and for forever, and still this administration wants to deny her child citizenship in the United States. It's not right, and I hope the Supreme Court sees through it tomorrow.
Let's put up the 14th Amendment one more time as we go to break. It's very straightforward. And again, this has been the law of the land since the 1860s. And it was reaffirmed that it means exactly what it said in 1898. There is no justification for any justice.
So stand back and stand by on this. Democratic Attorney General Rob Bonta of California, MS Now senior legal reporter Lisa Rubin. Thank you. We'll be looking for Lisa's reporting on this issue, including her sit down with some of the attorneys leading the charge online at MS Now.